Last time, we uncovered how public interest became the excuse for every power grab. But to make that excuse permanent, the courts needed a philosophy, something elegant enough to sound like justice and vague enough to mean anything. They called it substantive due process. Two words ripped from the Fifth and 14th Amendments, twisted until due process of law no longer meant procedure, but whatever the judge personally believed was fair. The Constitution said, "No person shall be deprived of life, liberty, or property without due process of law." The courts heard, "We decide what liberty means." This is Constitutional Outlaw. Episode 4, Substantive Due Process, when procedure masqueraded as principle. The original meaning, due process as procedure. When the founders wrote due process, they meant process, literal procedure. It guaranteed notice, hearing, impartial tribunal. You could not be punished without law, charged without trial, or condemned without evidence. Due process was a citizen's shield, a promise that government power followed rules, not rulers. That's what the framers fought for. But by the late 19th century, judges started asking a dangerous question. What if some laws are unfair even if the procedure is followed? That question sounds noble, but opened Pandora's box. Because once fairness replaces law, interpretation replaces restraint. The Lochner era, rights redefined. The first mutation came in Lochner v. New York, 1905. The state had passed a law limiting bakers to 10-hour days. The court struck it down, declaring that the right to contract was part of the liberty protected by the 14th Amendment. Nowhere in the Constitution does that phrase exist. The judges created it because they felt economic regulation was unfair. For the first time, due process stopped being about how the government acted and became about what the government did. Process had become substance. That single ruling turned the Supreme Court into a moral editor, rewriting legislation to match its mood. The result? Courts began vetoing laws on subjective grounds, not because they violated procedure, but because they offended judicial taste. They called it protecting liberty. But it was really the birth of judicial policymaking. The backlash, from protection to permission. After the Great Depression, the country turned against the Lochner court. Critics said judges were blocking reforms that might save lives. In 1937, under FDR's pressure, the court changed course in West Coast Hotel v. Parrish. They upheld wage regulation, declaring that liberty is not absolute. Just like that, the court reversed its own philosophy. The same power it used to strike laws for being too controlling now justified laws because they were controlling. Substantive due process didn't die. It mutated again. It became a two-edged sword. One edge invents rights from personal belief. The other edge upholds control in the name of the collective. Either way, the people lose, because the rules never stay the same. The post-war expansion, liberty reinvented. Mid-century, judges realized their new toy could also create popular rights. They began using substantive due process to declare new liberties that Congress never enacted and states never ratified. Griswold, Connecticut, 1965, the court struck down a ban on contraceptives, saying the Constitution contained penumbras, shadows of rights implied by others. A poetic metaphor, but also judicial alchemy. Roe, Wade, 1973, they extended the same logic to abortion, calling it part of constitutional right to privacy. Once again, the text said nothing of the kind. The meaning of liberty now lived inside judicial imagination. In both directions, economic before, moral after, the power was the same, judges deciding which freedoms matter. Some cheered because the results matched their politics. But liberty doesn't survive by luck. It survives by law. And once you let judges redefine rights, they can redefine them away. The modern era, from policy to puppetry. By the 1990s and 2000s, substantive due process had become the Swiss Army knife of constitutional law. Courts use it to justify same-sex marriage, parental rights, bodily autonomy, and privacy, and uphold regulations that contradict those very freedoms. They call it evolving liberty. That phrase sounds compassionate, but it's poison. Because if liberty evolves, then it's not permanent. It's negotiable. The same logic that created Obergefell could just as easily erase Heller. The same reasoning that declared new rights can also excuse new restrictions. It all depends on who wears a robe. And that's not law, that's ideology. The double-edged betrayal. Substantive due process is praised by both sides when it suits them. The left uses it to expand personal autonomy. The right uses it to defend economic freedom. Both pretend it's constitutional. But the truth is simple. A principle that justifies anything ultimately protects nothing. The Bill of Rights already defines liberty. The 14th Amendment already guarantees equal protection. Substantive due process is neither. It's a judicial escape hatch, a license to replace text with philosophy. That's why one day it's the savior of privacy, and the next it's the executioner of property rights. The consequence, rights turn inside out. The result of all this judicial creativity, citizens who can't tell whether their freedoms are permanent or provisional. You now live under a constitution of moods. A living document is a dying contract. When courts can redefine liberty based on headlines or ideology, you no longer live under rule of law. You live under a rule of lawyers. The founders warned about it. Madison said, if men were angels, no government would be necessary. But he never imagined angels in black robes pretending to be gods. The people's responsibility. We can't undo 2 centuries of rulings overnight, but we can strip away the illusion. Liberty doesn't come from penumbras. It comes from principle. It's time to reclaim due process as process. Fair rules, fair trials, not moral guessing games. When a judge says, it's for your own good, remember, every tyrant in history said the same thing. Freedom doesn't need invention. It needs protection. And protection doesn't come from courts that rewrite the law. It comes from citizens who know it by heart. If you don't know your rights, you don't have any. And if you let them redefine them, you won't even recognize what you lost. This is Constitutional Outlaw. The people's courtroom against overreach. Because justice doesn't plead bargain, and neither should you,